The European Union's General Data Protection Regulation, GDPR, comes into force on 25th of May 2018. What does your organisation need to do to comply with the new law? In this session, we discuss data protection impact assessments. A crucial first step towards GDPR compliance is to analyse and identify your organisation's role in relation to personal data. You might be a controller, responsible alone or jointly with others for determining the purposes and means of processing personal data. Or you could be a processor, processing personal data on behalf of the controller. GDPR imposes some direct obligations on processors, but it also carries a number of indirect obligations. DPIAs, Data Protection Impact Assessments, provide a good illustration of this. The duty to carry out a DPIA, where applicable, falls on the data controller. Processors have no direct duty to carry out a DPIA, but they do have a duty to support and facilitate compliance by the controller. Consequently, processors must provide relevant information, such as data mapping or details of any data security measures that have been undertaken. GDPR compliance depends on accurate mapping of data flows into, out from, and within an organisation. It's worth paying particular attention to cross-border or international transfers of data, because transfers of data outside the European Union or European Economic Area are prohibited unless there are sufficient safeguards in place. GDPR compliance also depends on an assessment of the risks to data subjects posed by particular types of processing. For example, involving special categories of data, such as health, religious or philosophical beliefs, sex or sexual orientation, and also automated processing or profiling, leading to significant decisions affecting individuals. What is a data protection impact assessment? A data protection impact assessment, or DPIA, is a documented process. It's a way of delivering, embedding and evidencing privacy by design and privacy by default, which are core elements of GDPR. This is not a new concept. Under the old data protection law, they were referred to as privacy impact assessments. The UK regulator, the ICO, published a code of practice on conducting privacy impact assessments. That guide, that code of practice, is now being updated fully to reflect GDPR. Data controllers must carry out a DPIA prior to carrying out a processing activity that is likely to result in a high risk to the rights or freedoms of natural persons. High risk is not itself defined under the GDPR. Supervisory authorities, which include the UK's ICO, are required to publish lists of when DPIAs are or are not needed, though, as and when published, those lists will not be exhaustive. It'll still be a matter for the data controller to assess for itself whether processing is likely to result in a high risk in many circumstances. The GDPR sets out specific circumstances where a DPIA is required, and they're set out in Article 35(3). They are where we have systematic or extensive automated processing, including profiling, used in significant decisions affecting an individual, where there is large-scale processing of special categories of data, or of personal data relating to criminal convictions and offences, or where there is systematic monitoring of a publicly accessible area on a large scale, for example using CCTV. While those circumstances set out when a DPIA must be undertaken, it is always possible for a controller voluntarily to carry out a DPIA, and that is recommended as good practice in many circumstances where risks are at the outset unquantified. Where a DPIA is carried out, it must cover and include a description and a statement of the purpose of processing. It must include an assessment of how necessary and proportionate the processing is in relation to that stated purpose. That reflects the data minimization principle. It must include an assessment of privacy risks posed to the data subject by that processing. And it must describe and evaluate any measures, safeguards and mechanisms your organisation will use to mitigate risks and to protect personal data. When carrying out a GDPR DPIA, you should consult your organisation's data protection officer if one has been appointed. ICO recommendations also suggest that it's good practice to consult with affected data subjects and/or their representatives. While that does represent good practice, it's necessary to bear in mind any confidentiality obligations that might restrict your ability to carry out such consultation. One DPIA can cover several similar high-risk processing operations. This is an ongoing process. Your data processing needs to be reviewed against your GDPR DPIA, at least when there is a change to the risk of processing. That could arise where a new system or procedure is adopted, where a new processor or sub-processor is appointed, or where the categories or purposes of processing change or expand. Even if a GDPR DPIA is not strictly required, it remains good practice, and even where you've carried out a voluntary DPIA, that must be kept under review, just as a compulsory DPIA must. Crucially, any change to high-risk processing after May 2018 will trigger the need for a DPIA. One possible outcome from your GDPR DPIA could be the identification of high-risk processing activities that could be managed through a range of mitigation or control measures. GDPR Article 36 requires the controller to consult with the supervisory authority, that is the regulator, prior to processing where an impact assessment under Article 35 indicates that processing would result in a high risk in the absence of measures taken by the controller to mitigate that risk. The purpose of this prior consultation is to allow the regulator to assess the mitigation measures that your organisation proposes and to determine whether those mitigation measures would be sufficient to ensure that data subject rights are adequately protected. Where the supervisory authority is of the opinion that the intended processing would infringe GDPR, in particular where the controller has insufficiently identified or mitigated the risk, the supervisory authority has a period of up to 8 weeks within which to provide written advice to the controller and, where applicable, to the processor, setting out steps that can and should be taken to improve risk management or mitigation. If the supervisory authority concludes that no further viable steps can be taken, for example because the controller has insufficiently identified or has insufficiently mitigated the risk, then the supervisory authority may make use of its powers under Article 58. Importantly, those powers can include orders preventing processing. The 8-week period may be extended by up to 6 weeks, taking into account particularly complex or complicated processing activities. One area of particular challenge when it comes to the GDPR in general and to DPIAs in particular is accommodating big data. GDPR requires a DPIA where there is systematic and extensive evaluation of individuals based on automated processing. That includes profiling, where decisions based on that processing significantly affect individuals. Big data, coupled with predictive analytics, makes it difficult to describe data flows and to specify precise purposes. That's because the very purpose of the discovery phase of big data analytics is very often about finding new and unsuspected correlations in large volumes of structured and unstructured data. Consequently, it can be extremely difficult to specify the precise purposes of processing before the outcome of that discovery phase is known. For that reason, consent is unlikely to be a viable route to lawful processing under a big data system. It also creates some difficulties when it comes to ensuring privacy by design and by default. The ICO has emphasised that GDPR should not be a barrier to the use of sophisticated technology such as big data analytics. But it remains essential to check how big data processing is intended to work and to take steps towards compliance with GDPR. That means in practice that big data is highly likely to require a full data protection impact assessment. If you have any queries or would like to seek advice on any of the issues raised in this webcast, please contact our data protection team. Contact details are on your screen at the moment. Thank you for listening to this GDPR webcast. Please join us for our other sessions on data controllers, data processors, data protection officers, contractual issues for GDPR, and responding to personal data breach.